relationships with the territories upon which York University campuses are located. To foresee the establishment of York University. York University acknowledges its presence on the traditional territory of many Indigenous nations. The area known as Tookarondo has been caretaken by the Anishinaabe Nation, the Haudenosaunee Confederacy, and the Huron-Wendat and the Métis. It is now home to many Indigenous peoples. We acknowledge the current treaty holders, the Mississaugas of the Credit First Nation. This territory is subject to the Dish with One Spoon Wampum Belt Covenant, an agreement to peaceably share and care for the Great Lakes region. Before we get started, a couple of announcements. We have a full calendar of lunchtime talks this week. We have one tomorrow and on Thursday, so please come out to those as well. We have two excellent speakers. David Vinegar, who is probably the foremost authority on refugee law in Canada, and he is an alumni of York University, a graduate of Osgoode Hall Law School, and first started working in this field before the establishment of the Immigration and Refugee Board, and served as general counsel for many years at the Immigration and Refugee Board, and is still there now. So anyone who's interested in refugee law and refugee policy should come up tomorrow. And then we have Joey Coleman, who's going to be speaking on Thursday. And Joey Coleman is a fellow at Massey College at the University of Toronto, but he's a working journalist, and he's going to be speaking about transparency and public policy at the local level. So if you're interested in local government and issues of policy making at the local government and decision making there, please come for that as well. Today's speaker, Michael Giudice, thank you, is a professor of philosophy here at York University, and he's the co-founder and co-director of our JD MA Philosophy program. And his area of specialty is philosophy of law, and he focuses on questions dealing with general jurisprudence, international law, an area of interest of mine, constitutional law, legal pluralism, and methodology. And he's published extensively, including two books, one single-authored, Understanding the Nature of Law, a case for constructive conceptual explanations, and another with Keith Culver, Unsteady State, General Jurisprudence for Dynamic Social Phenomena. And today he's going to be talking about a topic that he's told me that he's doing some major work on. So we look forward to hearing Michael on social reconstruction of state-indigenous legal relations in Canada. Welcome, Michael.
Thank you very much. And thanks very much also to Vicky for helping organize as well. It's quite nice to be here to give this talk. So I hope it's not going to be too awkward with a small group having slides. I'm trying not to talk for so long so we can get to some questions. What I want to talk about, mainly to share some ideas, some observations about state-indigenous relations in Canada and ways in which I think those relations might be changing. To use an expression, they might be undergoing some social reconstruction, and to explore a little bit why that social reconstruction might be an improvement, a good thing, especially for goals and objectives of reconciliation. So there are a couple of perspectives, or I might say general lenses that I've been using to think about settler Indigenous relations in Canada. One of them, probably quite familiar, the idea of social constructionism, the idea that some of our facts in the world, some of our categories and ideas in the world don't depend on nature, but depend on our inner subjective beliefs, or our shared beliefs, intentions, and practices. So easy examples, we've socially constructed the idea of money, so we attribute significant status to particular objects, flat, round pieces of metal, count as loonies and toonies. Also, my favorite sport, soccer, also social construction. So putting a little round inflated ball between two posts counts as a goal. Because we've created this practice, we attribute that significance to that activity. Now often, social constructions can be quite harmless, can be quite useful. Money, quite useful in some circumstances. Soccer, quite fun. In other instances, social constructions can be dangerous and sometimes downright oppressive. Now, one of the purposes of social constructionist thinking is to expose, as a product of our own choices, political, social products, what might otherwise be considered to be natural or necessary or inevitable. So much of the work on our gender concepts, for example, is meant to do that. It's meant to challenge the roles and the ideas and the ways of thinking about genders, to move away from the idea that they might be natural, inevitable, or necessary. Now the second general lens, so that's going to be a theme of my talk. I'm not going to talk so much about social constructionism directly, but it's going to be one of the themes that I draw on just in my remarks today. The second perspective, I'm a legal philosopher, specifically an analytical legal theorist. Analytical legal theory is one type of legal theory, certainly not the only. It's concerned mainly with conceptual questions, so the big philosophical 101 questions: what is a legal obligation? How is law different, similar to morality? What is law? So these big organizing questions asking to think about these basic frames of thinking. And a central aim is to try and analyze and clarify these conceptual frameworks for use in other types of investigations, maybe more social scientific or moral investigations, and with the goal of identifying but not resolving issues of practical, moral, and political significance. So one of the main concepts that analytical legal theorists have analyzed and attempted to clarify with these particular aims in mind has been the concept of a legal system. Now, the concept of legal system, it's a prominent way of thinking about law, not just in legal theory. I'm going to give some of the characteristic features of legal systems in the philosophy of law, but also it's a practical political commitment that states often adopt in the way in which they organize society and governance and so on. Now, the concept of legal system plays a quite prominent role in legal theory because it answers a very important question. It has been taken to be the key way in which law, understood as a certain set, collection of norms, is to be distinguished from other types of norms, moral norms, norms of etiquette, custom, even normative systems like universities, which have all sorts of rules and regulations. So in analytical legal theory, the idea of a legal system is what helps us to distinguish morality, custom, for example, on the one side, from law on the other. Legal norms, they might include, have the same content or say the same things about morality and custom. But legal systems and law are distinctive because they form a certain kind of system which occupies a particular place in society. So what I want to do is explore this idea a little bit further. Often in thinking about state-indigenous relations, the main concept which tends to be challenged and investigated is sovereignty, for quite natural reasons, quite understandable reasons. But I want to suggest that the concept of legal system is just as important to challenge and investigate and maybe even more so because it's more entrenched, right? It often goes without notice as a prominent way of thinking about law. So what I want to do first is pull out some of the particular features of the concept of a legal system. So some of the features that have been identified as core to the particular concept. So the first one, legal systems only exist where there are special practices, social practices. So we have a social practice in Canada of recognizing the enactments of Parliament as law. Right? We've got judges, police, other legislators, and even private citizens who, as a matter of social practice, recognize Parliament as being a source of law. If we didn't socially recognize Parliament, it wouldn't be a source of law. It wouldn't be a legal institution for us. So legal systems, their existence depends on social practice of recognizing them, accepting them as sources of law for which society is to be regulated. So that's one feature. Second feature, legal systems also have this two-tiered structure. So legal systems typically have these basic primary rules of behavior. Do this, don't do that, pay your taxes, observe the criminal law, don't assault, murder, and so on. But also a legal system exists when there are the second level of rules, in which there are institutions and ways in which we can change the primary rules. We can solve disputes. We have courts. Courts have particular rules they follow. And also a kind of master rule, a rule of recognition. This sort of sums up. So in Canada, Parliament's a source of law, but also the courts are sources of law, provincial legislatures are sources of law, the Constitution. So a rule of recognition says that in Canada, we recognize these diverse sources of law, and we typically rank them. As I mentioned, so the idea of a legal system that helps us to think about validity. This rule is a rule of law, that rule isn't. Why? Because rules of law get validated, or they have membership in the system of norms. They're recognized as coming from an appropriate source, a parliament or a court, for example. This unifying task is typically accomplished by some single foundational rule, which organizes the sources of law. For those who are familiar with legal theory, H.L.A. Hart had this idea of a rule of recognition. Hans Kelsen had this idea of a basic norm. These are ideas that they introduced to try and make sense of a legal system as a kind of group, a clustering or a membership of norms. And as I mentioned, in legal systems such as ours, where we do have multiple sources, a legal system will rank them. Right? So in cases of conflict, there's a certain priority, there's an order, a hierarchy to resolve disputes. A couple more features of legal systems. Here's one which distinguishes legal systems from, say, university systems of rules. So legal systems typically claim supremacy. So often our courts will invoke norms or rules from other organizations or other social groups. An Ontario Court of Appeal might, for example, refer to university regulations in making a decision. Those university regulations don't become law, but they become used by courts for particular purposes. International law is a great example. International law in Canada requires incorporation, right? So international law doesn't apply to us directly in most instances. There's some exceptions that are worth thinking about, but typically, as our Supreme Court has recognized, international law only becomes adopted and used for resolving disputes when it's been incorporated or brought into the system. This is part of the feature of supremacy, that these other non-legal or foreign or international sources of law require a kind of stamp of approval in order to be brought into to the system. And where they do operate, it's in virtue of some delegated power or authority. Now, one implication of these supremacy claims is that you can only have one legal system in existence. That's sort of commonplace. You could have multiple claims being made, but you'd likely be finding yourselves in a situation of instability, where legal order might not be fully settled or established. Another feature of legal systems, there's just one more after this, independence or autonomy. So legal systems are also understood to be self-standing sets of rules and regulations. They're meant to provide for their own foundation. Think about pulling themselves up from their own bootstraps. They provide a way of determining what's law within the system and what's not. And that way you could say they provide a kind of normative closure. So what's included in the system, what counts as law, will be used by courts and police and so on. Those shots are called by the system itself. It is deciding what is law and what's not law in some time and place. And finally, just a last one, comprehensiveness. So legal systems also typically assert authority to govern all aspects of social life, all subject matters, the use of violence, family, contracts, employment, as well as the territorial or spatial domain. So there's a Canadian legal system, which is to say there's a legal system which applies over the entire territory of Canada. And in some way, all action or all conduct is governed by the legal system, either by being prohibited, think of the criminal law prohibiting certain forms of interpersonal conduct, required, think of tax law, restricted, some things we can do, but only under certain conditions and with permits and with constraints, or permissions. Law regulates by sometimes allowing us certain freedoms and liberties. But all conduct is, in some sense, regulated in one of those four ways. Again, across subject matter and across territory. Now, these aren't just, I want to mention, I'm not defending these particular features either. These have been features which have become the central way in which law has been distinguished from morality, from custom, from etiquette. It is typically the way in which legality, right, the idea of law itself, as explained. And what I want to suggest now is that it's not just a theory which philosophers in their offices or in their ivory towers, I've never actually seen an ivory tower or philosopher in it, but probably not familiar with the expression. But they're not just abstract features which philosophers have conjured up to distinguish law. They're actually features which are a reflection of many state practices. And the idea of legal system is often closely associated with the idea of the modern sovereign state. So just a couple of examples from Canada. Our very Constitution makes it plain, explicitly claims that it's the supreme law of Canada. Any law that's inconsistent, there's no force, the provisions of the Constitution, has no force or effect, the extent of that inconsistency. So any norms which have applicability either meet the conditions in the Constitution or they don't. And they don't, they're not of legal force or effect. We also have a hierarchy of norms, Constitution, statutes, and precedents. And our highest judicial institution self-presents as the Supreme Court of Canada. Right, again, a claim of supremacy is made right in the court. It takes itself to be an authority on, again, a whole range of issues which the law regulates in Canada. I'm not going to get into, I think it's an interesting question, just how independent or autonomous we are, given we're a former and in some ways still a British colony. If you think about our constitutional structure, the monarchy, there are some complications to that particular view, given our history. But for the most part, we can certainly talk about those, but for the most part, Canada exhibits through its legal system these various features of what a legal system is. Now, in practice, the concept of legal system can often turn into assertions. So one thing I want to emphasize is that this idea of a legal system, again, it's not just an abstract tool, but it's a particular way of thinking about law, a particular way of knowing law. It is a particular way of answering questions about what the law is in some time or place. Can there be freestanding laws? The answer is no. They always have to be validated through a system. Does the system itself depend on the existence of some other external sources of law? No. A legal system is one which has its own foundations, they're internal. Are legal systems the basic units of law? Yes, because you can't distinguish laws from morality without the idea of a legal system. But in practice, this concept, philosophical concept, can often turn into practical, political commitment, and one more, I think, useful of explaining that is to use the expression as an assertion of legal system. So in Canada, the assertion of legal system is perhaps most prominent, or at least among the most prominent ways in which we can see it, is in relation to Aboriginal Indigenous peoples in Canada. So to give you another couple of examples, in our Constitution Act, 1867, and still up till today, till 1982, sections 91 and 92 divide authority, divide jurisdiction, without remainder, between the provinces and the federal government. There are no authority or jurisdiction in the Constitution, so part of our supreme law, for Indigenous groups, or, as you'll remember from last fall, for cities. Think here about Doug Ford cutting City Council of Toronto in half, almost in half. Cities don't have any constitutional standing. So another example, the Indian Act, first enacted in 1876 and still in force in many ways, and represents in many ways a complete assumption of authority by the federal government over all Indigenous issues. So in relation to Indigenous peoples, we can see the assertions of legal system, comprehensive. The Indian Act was meant to govern comprehensively as well all of the Indigenous issues with regard to rights, practices, religion, land, especially, and so on. So to come a little bit forward from 1876, since then, within the last 50 years, there has been a shift in the way in which the state has related to Indigenous persons. So if you think of the Indian Act, that was essentially a transitional law meant, by all accounts, for the extinguishment of Indigenous people. Right? It was meant to try and transition out of a state of affairs in which the country had Indigenous minorities, as they understood at the time, to full, mainstream, integrated Canadian citizens. Now, in the last 50 years, things have changed, so it's no longer been practice of extinguishment to the same degree, but rather, by means of constitutional amendments and Supreme Court cases, there's been greater recognition of Indigenous rights and practices. So, just by way of a few examples, our sections 25 and 35 recognize and affirm Aboriginal rights, including treaty rights. There's been legislation, including amendments to the Indian Act to repeal certain provisions, and judicial definition. So beginning with this case, Calder in 1973, followed by subsequent cases, there's been the attempt to try and define what it would mean for Aboriginal rights to be proven and established in particular places and time. Probably the most landmark case is a recent case, the Chilcotin decision of 2014, and I'll talk about it in just a few minutes. But these are all what we might call systemic recognition. So recognition of Aboriginal rights as defined by the Supreme Court is a way of defining Aboriginal rights within the terms set out by the Canadian legal system itself. While there are Aboriginal rights that are constitutionally entrenched, still these rights are part of within the Constitution, subject also to amendment, which would not require any kind of formal, they require consultation with Aboriginal persons, but there's no final word given to Aboriginal persons or Indigenous groups about any amendments to the Constitution. So these are within the systems. So by systemic, I mean the system itself is recognizing changes. Now, it's clear that systemic recognition, even if it were to include recognition of all Indigenous rights, I think of fishing and hunting and land governance and land possession and so on, there would still be a problem with recognizing Indigenous rights through the Constitution itself. So to give you a few examples, so Dale Turner in his book, This Is Not a Peace Fight, many Aboriginal peoples do not understand their rights in terms that are amenable to the state's legal and political discourses. This is because many Aboriginal peoples do not perceive the political relationship as one of subservience or one as having delegated authority or authority given to them. That is, they do not view their rights as somehow legitimated by the Canadian state. Rather, many Aboriginal peoples understand the political relationship as one of nation to nation. Now this is many groups, it's not all of the groups, but I want to focus on the idea of a nation to nation or partnership or government to government relationship in a few minutes. A couple of other examples, famous Mohawk lawyer and scholar Patricia Montour-Angus, here remarking on the supremacy claims as exhibited through the Supreme Court. So one of her statements, there's an insurmountable problem in taking Aboriginal claims to territory before the courts. Courts owe their creation to the fact of Canadian sovereignty. They cannot question that sovereignty because to find it wanting would in fact disestablish their own legitimacy. So, as she's claiming, there are ways in which claims to Aboriginal territory and rights undermine the very supremacy that's understood and assumed by the Supreme Court as an institution. Another example, Aaron Mills, the court's an institution internal to Canada's constitutional order and its creations by and under its authority. They're by definition incapable of taking up the very issue at stake in treaty, and that's the coordination of distinct constitutional orders. So here, as I mentioned, even if somehow the courts resolved all Indigenous rights issues in a way which recognized all of the claims, there would still be a problem with the status. There would still be a recognizable and understandable difficulty with recognition which comes from within the system itself. So I want to look at a couple of, two or three examples here where we might be witnessing, and here's why I want the theme of social construction to I think it's of use, we might be witnessing some reconstruction of that systemic recognition, of that idea that Aboriginal rights and practices somehow get constitutional protection or validation through the system. So here's an example. There's a case in 2014 in Chilcotin. People are about 1,800 square kilometers north of Vancouver, in BC. What's of interest in the Chilcotin Nation are copper and gold interests, which often resulted in incursions into Chilcotin territory. 2014, the Supreme Court decided not only was there an Aboriginal right under certain conditions, but the decision in 2014 was the first one in which it was actually recognized, a particular Aboriginal claim to land was recognized. So those earlier cases, Calder, Delgamu, Vanderpeet, their Aboriginal rights were defined, and the tests for proving Aboriginal rights to land were established as defined by the court, but they weren't recognized in those cases. The test was developed, but not recognized. So Chilcotin in 2014 stands out in that respect. That 1,800 square kilometer territory was in fact recognized as Chilcotin territory. Now, what I find particularly interesting is not the case itself, which is part of the context, but this 2017 letter of understanding between the Government of Canada and the Chilcotin Nation. Now, this was signed between the Chilcotin National Government, which represents 4 or 5 First Nations in the area, and it's characterized as a nation-to-nation relationship or a government-to-government relationship, as it's sometimes characterized. And it's a commitment between Canada and Chilcotin Nation people to recognize that there's inherent laws, customs, jurisdiction, and responsibilities that the Chilcotin people have used and govern themselves by prior to the arrival of Europeans, prior to the formation of Canada. Now, what's remarkable about this letter of recognition, letter of understanding, it's not a constitutional amendment. So it's not an amendment under the formal amending process for Canada. It's also not a federal law. It's also not a federal policy. There have been federal policies, the inherent rights policy, for example. It's also not a Supreme Court decision. There was a Supreme Court decision, but this is not one of them. It's something different. And you might say, well, that might be part of its flaw or part of its defect. Right? It's got no legal force. It's not an amendment to the Constitution. It's not a federal statute or policy, not a Supreme Court decision. Doesn't that make this somewhat ineffectual or without value or bite? I want to suggest that those actually might be fairly good features, that it in fact stands outside the hierarchy of sources of law. The Chilcotin Nation don't have any constitutional authority under our Constitution Act 1867. There is no provision for striking these kinds of agreements as there would be between federal and provincial governments. So in a sense, standing outside the hierarchy of norms might be a positive feature rather than a drawback. Here's a second example. Haida Gwaii, most of the island just off the coast of, again in BC. Again, Haida Gwaii in 1985 was prominent in the news. There's all sorts of old growth forests, and up until 1985 there had been incursions in Haida Gwaii lands by logging companies, cutting down these old growth trees and forests. In 1985, the Haida Nation objected, protest, blocked any further incursions into territory, and that set off a series of negotiations in which the province of British Columbia and the Haida Nation attempted to resolve disputes about land and territory, resulting in, eventually, this was not the first step, but eventually after quite a bit of battling and challenging and fighting, I know I'm going to mispronounce it, Kunstaya Reconciliation Protocol. This means in the beginning. So this is meant to form a new beginning, a new kind of relationship between province of British Columbia, or the government of British Columbia rather, and the Haida Nation. What was remarkable about this is it's not quite as clear and straightforward as the letter of understanding between Canada and the Chilcotin people, but it actually recognizes right in the protocol, right in the reconciliation protocol, a dispute, a disagreement. So in the protocol, again signed by the government of BC and the Haida Nation, it says that here's a statement from the Haida Nation: Haida Gwaii's Haida lands, including the water and resources, subject to the right, sovereignty, ownership, jurisdiction, collective title of the Haida Nation, who will manage Haida Gwaii in accordance with its laws, policies, customs, and traditions. And almost right next to that statement, you've got a statement from the government of BC saying Haida Gwaii's crown land, subject to certain private rights or interests and subject to the sovereignty of Her Majesty the Queen and the legislative jurisdiction of the Parliament of Canada and the legislature of the province of British Columbia. So you've got this recognition of clear dispute and disagreement. And you might think, well, that's not quite as nice and straightforward as a letter of understanding, but on the other hand, it's much better than the unilateral assertion of the Queen over Indigenous territory. And as that protocol was meant to signal, it's meant to be the beginning of a form of shared governance, a form of government to government, shared partnership, or a true partnership between British Columbia and the Haida Nation, such that any developments, any projects, industry or otherwise, have to begin from the start with discussion between government of BC and the Haida Nation. Now these two examples, I'll give you just one last example. Again, I think the Reconciliation Protocol is interesting precisely, not in spite of, but precisely because it's not a constitutional amendment or federal law or policy. Rather, it's outside the system. It's, as you might say, kind of non-systemic recognition. Here's a third example. So those two examples are kind of located in BC and restricted to parts of what's now British Columbia. Here's a more general one, a more national example. 1996, a framework agreement on First Nation land management. This was signed by the Government of Canada and again 13, sometimes recorded as 14 First Nations. It's a government-to-government agreement, and its central purpose is to allow First Nations to opt out of the Indian Act, and in particular to opt out of those sections of the Indian Act which have to do with responsibility use of reserve lands and resources. One of the really interesting features of the Framework Agreement is that it allows First Nations to develop their own land codes, but in addition, part of those land codes can include criminal offenses. So First Nations have the authority to create offenses which are in light of or based on traditional customary beliefs about the lands, and to actually turn them into criminal law, which the rest of the country, the rest of the government would be under an obligation to enforce. Now that's remarkable. Criminal law historically has always been a matter of federal jurisdiction. Only Parliament can change the criminal law. This framework agreement is recognizing that criminal law, criminal jurisdiction can be shared in certain instances and certain subject matters. Now it serves as, so this is the Land Advisory Board, the Resource Center, a kind of joint institution between First Nations and the government, kind of hybrid institution. And it says that the framework agreement is served as a source of law for both First Nations to create land codes and opt out of the Indian Act, but also as an obligation for governments, provincial and federal governments, to cooperate and coordinate with law enforcement and also their own legislation and policy. So it's being understood as a kind of foundational source of law for both Canada, again as a party, and First Nations. Now what I want to suggest is that these letters of understanding, there are others, these are just three that I picked out, but they seem to be becoming more and more common and prevalent as ways in which First Nations, in combination or in a horizontal relationship with federal and provincial governments. I think that these letters of understanding, these protocols and framework agreements show that the idea of legal system, it's not a necessary way or inevitable way of thinking about how one type of legal order, state legal order, and another type of legal order, such as First Nations legal orders, must relate, where these coexist in the same place at the same time as a matter of social fact. So the legal system then might be one way in which we've socially constructed the idea of law that might not be necessary. And I think what I want to suggest, and maybe just end on this, to the extent to which these sources are recognized as constituting new basic relationships. Right? The letter of understanding, it reconceives the way in which Chilcotin people and British Columbia and the federal government relate to each other. They might have the potential to become new sources of constitutional order. Now this is not to suggest that social reconstruction can happen all at once, or in an easy way, or a way without problems. We know that's not true. Try and think of socially reconstructing our ideas of gender, or even race. It takes time, takes challenges, takes reconceiving, reimagination, changing, shifting attitudes. So what I want to suggest is that these sources, protocols, letters of understanding, they do have the potential to serve as foundational norms and foundational ways of conceiving of First Nations and state and provincial federal governments, if they take hold as basic obligations and sources of responsibility. And if they do serve as new sources of constitutional legal order, I think they'd be best described as a coordination. So think of Aaron Mills' passage, statement talking about trying to coordinate distinct constitutional orders on the basis of treaty. So they could be coordination of legal orders rather than subsumption of one into another. So it could be a non-supremacy relation. They would be recognized as partnerships rather than hierarchy at their foundational. So instead of a hierarchy of official institutions, federal government delegating power to First Nations, it would rather be a partnership. And it could be mutual recognition of limited, i.e. non-comprehensive jurisdiction. So for example, First Nations control land with limited criminal law powers. This is a way in which you've got a kind of retraction of a supreme claim to authority. Just to finish, hands going up, these particular types of new agreements and understandings not only have the, I think, potential, this is interesting for philosophers of law, because it really does disrupt and displace a very core and prominent way of thinking about law, and I think it's interesting for that reason, but also there are good moral and political reasons for thinking that supremacy might, or legal system rather more generally, isn't the best way to think about law in contexts where there are goals and objectives of reconciliation. A non-systemic coordination of constitutional orders, I think, is more responsive to the criticisms that we hear from Dale Turner and Patricia Monterangus and many others as well. Thank you.
So let's open the floor for questions.
Yes, sir. May I ask, please?
Yes, please.
Okay, what you just said about the government, instead of acting like a hierarchy, instead giving them somewhat of the same power, that reminds me of the Magna Carta, and almost like the way the Magna Carta worked, because isn't that how King John of England made the barons submit to his will by giving them power like that? And that's how the first parliament was formed over in Britain, even way back in the very early days of England. Isn't that something like, because that rang a bell with me, and it just reminded me of the Magna Carta that was signed.
Right, which eventually led to the very doctrine, the idea of parliamentary supremacy in England, yeah. I think I'd want to object to the first way that you framed it. So the reconciliation protocols and letters of understanding as forms of the federal government giving authority to First Nations. I think that's where the social understanding might be changing and shifting.
As opposed to making them submit to their will, like making the barons submit to the will of King John. Sort of like he gave them a deal sort of thing to make them like fellow heirs rather than something beneath their feet, beneath his feet sort of thing. Something. So,
I mean, I don't want to run with the analogy too much, but maybe just to suggest a further line of thought. So, the idea that legal systems and ways in which governments try and recognize authority of other groups, whether it's municipal, like city governments, or First Nations, or even religious groups for the purposes of education. The idea that those relations are best characterized as systemic, so that there's supremacy claims being made. It's not just going to be a one-off. So what remains to be seen is whether for example, the Haida Nation and the BC government, how does that reconciliation protocol, how has it actually changed practices? Right? Has it just been a way in which you can appease a certain group so that they resubmit, or so that they willingly, for example, to contrast with historical evidence, so that they willingly submit to the central authority? I think that's where there's potential for something different to happen. Right? If the Haida Nation and the federal government no longer see it as a submission of will from one to the other, but rather, and by all accounts, this is what I think is happening in Haida Gwaii, it is a shared partnership. There is no submission from one will to the other. Right? But I can see the analogy with England and the Magna Carta. Right? That was the sort of the precursor to parliamentary supremacy. But if this takes hold, it's quite different. right? It's not trying to figure out whose will is supreme and how do we get people to voluntarily agree to it, but rather how do we recognize jointly shared authority in some circumstances. Yeah, so I'd want to resist the idea that submitting to will is the best way to think about these particular phenomena. Yeah. Thank you.
So thank you very much for the lecture, Professor. Number of questions. First, a clarification question. The 2017 letter from the federal government to the First Nations, you call that a non...
Not from, between.
Between, sorry, yes.
It's not like
you
a
call
royal
that...
proclamation.
Correct. You call that non-systemic because it is essentially in and of itself of no force of law, correct? Or do you call it...
Within the Canadian legal system, that's right.
Gotcha,
Right.
okay. But the Canadian the Canadian government itself would be technically systemic, right? Okay, I just wanted clarification for that. And why are you so optimistic regarding this thing that you yourself said, which was a criticism, is essentially of no legal power or authority? So what is to stop, say, the government of Canada from saying, yeah, we're going to talk to you nation to nation, and then doing what they do with the consultation process, where they go in, they say, yeah, we're going to consult, but ultimately you're going to give this land to us. It just, all we're doing here in this consultation is what price you want for it.
Right, so let me say a bit about my optimism maybe that you read.
Yeah.
So the optimism, first and foremost, is about an alternative way of thinking about state-indigenous relations. That, I think, is not to be undervalued or underestimated. We went for 150 years with the same idea about what it means to have law, what it means to recognize the source of law. So the idea that there might be an alternative way, a way of loosening the grip that the idea of legal system has had and has held, not just in Canada, but also we see it in the European Union as well, a sort of back and forth over whether member states are supreme or the European Union is, sometimes to ill effect, right? It's a gentle way of putting Brexit, characterizing Brexit. But that's not to be undervalued, right? This is a new way of thinking about how you recognize and coordinate different sources of law within the same time and place. Now, that can be distinguished as well from the optimism. How well is this actually going to work in particular practices? Even in the last month in the news, there's problems with Chilcotin boundaries being respected by companies, by industrial companies. Pipelines are also going to pose a huge problem for trying to, partner to partner, come up with solutions to different practices. Haida Gwaii is a good example where it seems to be working in many respects, but for much of the country it doesn't seem to have taken hold. So, and to give you another example, in parts of Quebec and Ontario and bordering parts of the U.S., it's not a partner-to-partner relationship which is being conceived, right? For the Haudenosaunee or Mohawk peoples, it's not partner-to-partner, which is often sought. It's rather a form of guest responsibilities. Right? It's not that there's a partner-to-partner. It's rather that through the Iroquois Confederacy, there's been permission granted to European settlers. So it's actually legal system, but in the reverse direction, from indigenous to settlers. And in my own home province of New Brunswick, there are virtually no reconciliation protocols of these kinds, or that is understanding. Rather, it's land has been ceded unjustly in most instances, virtually all instances, to be honest. And there's redress or compensation sought for those unjust cedings of land. So it's not going to be a model that's going to work for all Indigenous groups in Canada. There's quite a bit of variation. And my optimism is mostly to do with the reimagination of the relationship. That's where I think there's quite a bit of promise. It's a new way of thinking about these relations. Now, the challenge, I think, is here's where the philosophy comes to an end, and rather it's political advocacy and change. How do you spread that? How do you actually get the social reconstruction? How do you actually change people's views about gender? It's a social view that needs to be changed, so it has to kind of take hold and spread. And the conditions under which that's going to be successful and work That remains to be explored. What is it about Haida Gwaii where it's working so well, but say not through much of Alberta where there's objections to pipelines and so on. That's where my optimism is. I'm not sure if it's optimism yet. I think that's probably too soon. That's where we need to work, I would say. Thanks.
I'm not so certain how realistic this view is. If we say look at the vision of what this country should be in say 500 years, I think we all would hope that we have learned a lot from mistakes of the past, that people are treated with respect. And I think the vision that we see is that people in 500 years, they say, what am I? Well, I have ancestors who are Algonquian, Cree, Filipino, Chinese, European. I don't know, I'm just a Canadian. And so one would then think that the vision is that we have a colorblind society. I think, as illustrated by Martin Luther King, that every individual is judged by the content of their character. Whereas if we go this framework, then for lack of a better word, I guess what one sees is some sort of voluntary, friendly apartheid system. Do we really want to go that route?
Why do you suppose it be voluntary apartheid?
Because if in 500 years people are intermarried, who is a First Nations person? It's just going to be spaghetti soup. And there aren't people who have, who is an Indian, whatever that people are just going to look at each other and say, what is that? I'm just as much an Indian or First Nations as someone else, because if you have to look at family trees and say, okay, 3% of my ancestors are Cree, 2% are Chinese, it doesn't make any sense.
I'm not so sure. So it's tough. I mean, you weren't sure about how realistic it was, but
Like, isn't that a vision we want? That
yeah.
we don't want to have a separation, but we want people to come together, intermingle, respect each other, and that everyone has the same rights and responsibilities. No one has more or less.
Yeah, I mean, I guess a couple of thoughts. One is that if take another fact about our feature out of our constitutional order, or two more features. Multiculturalism as a part of the identity of Canada, multinationalism. Although multinationalism has so far only meant French and English. Those types of division, I mean, they tend to stay for quite a while. They don't dissolve and become spaghetti soup, I guess, quite so easily. What's not being contemplated here is that these are meant to be recognitions of new sovereign states. Again, with the exception, I want to be qualified about talking about the Haudenosaunee in Quebec and in Ontario, where sovereignty in the international sense seems to be the model, or seems to be close enough to the model. For Haida Nation and other parts of BC, it's not a kind of secession that's being contemplated. So you're right, it's going to be a kind of integration, a kind of coordination which respects those differences in customs, traditions, ancestry. Now, in 500 years, does that mean, is this a first step towards a kind of dissolution of these differences? I'm not sure about that. It's hard to guess, right? One thing we know now that's certain is that these distinctions based on if you're an Indigenous people or not, and your connections to land and traditions and customs matter, right? They do matter a great deal now. So whether in 500 years that means they're going to matter less, I'm not sure about that, yeah. So, I don't know if that answers your question at all. I'm just sort of thinking out loud on it. But if Canada, if what it means to, I mean, here's an example. So John Burroughs, who writes quite a bit about a kind of new constitutional order for Canada, is actually not proposing, what I find interesting about his work, he's actually not proposing a new coordination of distinct constitutional orders in Canada. Rather, part of his argument, as I read it, is that we've just forgotten in a very oppressive and pernicious way that there are at least three broadly understood nations that were part of the formation of Canada. The French and the English, of course, have gotten recognition. The English sort of a little bit more than French in many ways. But Boris's account is that it was also, at the time of first contact and time of settlement by Europeans, French, English, and Indigenous. And so in his book, for example, Indigenous Constitution, that's the argument he's making, is that actually, you know, it's not that we need to think about what's going to happen in 500 years, but rather we look backwards, we'll see that we've been quite mistaken, again, in politically grave ways, and who we recognize as our founding constitutional partners. So you might say in 500 years we'll still have French, English, and Indigenous. And you'll have different groups, Indigenous groups, just like we have different French linguistic groups. I'm not sure what your view about, you know, if Quebec really does secede or establish and maintaining a Quebec form of secular values, maybe it'll still be around in 500 years, I don't know. I kind of find that 500-year time range difficult to I know that doesn't really matter about 500 years, but
Do non-systemic recognition arrangements, such as the ones you outlined in that slide, have to operate within the broader legal systemic order? Otherwise, those particular systemic recognition devices are not going to have any force behind them.
right, yeah, no, that's a great question. The answer is there's going to have to be coordination. So there is a First Nation in BC called the Canucks First Nation. They were one of the First Nations to actually include a land code. So they opted out of the Indian Act and various sections, created their own land code, and part of that land code included new rules for eviction. So on the Canucks First Nation, they had two non-Indigenous people living in one of their residences, and they failed to pay their rent. That's kind of a mundane example. If they weren't paying their rent month after month, then the land board and the Canucks First Nation said, no, you're now trespassing, you have to leave. They went to, because they didn't have an enforcement institution of police, they went to the RCMP. RCMP said, this is not part of the law we enforce, we can't do it. So they went to the court. And the BC court, eventually the Court of Appeal, and the Court of Appeal said, well, it's no good to have these land codes if there's no way of enforcing them. So we're actually going to enforce the First Nations land code, even though it's not provincial legislation, and then direct the RCMP to go and do it. And what they allowed the Canucks First Nation to do in that case, it was a criminal case of eviction, was to actually assume the role of prosecutor. And that's again a remarkable feature, because in Canada, the only one who can prosecute a criminal offense is the state, right? Either the provincial attorney general or attorney general at the federal level. So here's an example where the First Nation actually, through the process of working out how to enforce their law, actually came to have a role very much like the state's role. Now, it gets really messy, though, because now the RCMP, after this case, are like, wait a minute, we have to learn the First Nations land codes as well? And the answer is yes. And why do you enforce it? Well, you enforce it because there's this framework agreement that has then set up provision of these land codes, and at the same time given obligations to state governments. So what you've got really is an entanglement where you do require institutions from both legal orders to coordinate. But what, again, I think is important to see in that is that the understanding, the basis of that coordination is not one institution over the other. It's not the state over Indigenous peoples, but rather the foundation. It's this partnership. But it is going to require quite a bit of Now, you might say, well, doesn't that just mean that the legal system is now broader than it was? It's just now got more sources. Legal systems kind of take on that persona, that kind of, think of the awful 1940s and 50s horror movies of the Blob. It just kind of sucks in everything that it touches. At which point you'd have to say, well, there must then be a legal system that coordinates Canada and the US, because we coordinate over borders, over travel, over employment. So isn't there just one single legal system including the US and Canada? You think, well, maybe at that point the concept is becoming stretched, that it's losing its explanatory, you might say, it's falling out of the explanation. It just seems that we can make whatever we want part of the legal system. So whether you want to say that the Canucks First Nation, the RCMP and BC are now part of one system, well, maybe, but maybe not. Maybe it's a different way of thinking about law. And more importantly, maybe it's better not to be always thinking about law in the terms of system, if it means supremacy, comprehensiveness, and so on.
Could I ask a follow-up question? Could it be perceived to be then a challenge, the way you describe the evolution of these different forms of legal systems being coordinated, a challenge to the supremacy of the Constitution?
Absolutely, yeah. That's a nice implication of the view. Yeah, certainly. Yeah. If you've now got recognition that these letters of understanding, reconciliation protocols, and so on are now new constitutional sources, and so they have, they actually constitute basic sources of law, right? Extra law outside the Canadian legal system, but they're meant to be, to sit alongside the Constitution Act 1867 and the Constitution Act 1982. They're in fact showing that the Constitution Act 1867 and 1982 isn't supreme in all instances. Rather, its supreme authority has now been diluted, distributed, shared, you might say. But yeah, absolutely. It might be in Canada that it's possible that we don't have, our Constitution may no longer be supreme in the same sense, if it now has to sit alongside these other sources. So yeah, and that's what the Indigenous scholars that I read, that's the claim they're making. It is a challenge to the supremacy. They're not asking for, in the ones that I've read again, so not speaking for them, Dale Turner and Patricia Monterangus, it's not a request for delegated authority, rather it's, this Constitution is not legitimate for us. It's not the supreme source of law for us. And hence the motivation for these new forms of agreement.
To say something like that assumes that the side that has been traditionally repressed is assuming hegemony. So what a lot of Indigenous groups want is either a revised constitution or a new constitution where Indigenous land claims, Indigenous values are supreme, and the laws of the settler are marginalized and diminished. So I see what you're getting at here. What we see on the screen here has a subtext, and the subtext is mutual recognition of limited jurisdiction by whom? Well, that implies that the Supreme Party is limiting the jurisdiction, in this case, of the First Nations. Whereas on the other side, the First Nations, many of them anyway, want to do the opposite to the settler and the settlers and colonizers. They want to diminish their law and their legal system and give hegemony to their own. So we have at least two forces at work here, possibly three. We have what you've got on the screen there. We've got the old way of doing things, the Indian Act, and we've got the new way of doing things, Canada's Turtle Island. And you and I, we're interlopers, we're settlers, and we have mistreated our hosts. We've been very impolite, to say the least, and unthankful guests. and it's time for that whole order to be changed and inverted.
In many instances, yeah. So I think the Haudenosaunee view is very close to that,
Yeah.
from what I've read. Yeah. I mean, one thing I want to say though is recognition. To think of recognition as, so if you think about social construction, maybe just to back up for a minute to the theme of social construction. So that something counts as money or a goal requires that the people who engage in the practice see it that way, that they actually adopt those ways of thinking about their activities. And sometimes, there are some instances where you do have a dominant group, and it's their intentions, their beliefs, their practices. So you could actually say, look, we're all going to treat this particular object as money, and there might be some dissenters who say, no, I'm not going to, but they might lose out. Right? The dominant group can actually impose their intentions, beliefs on others. And this is true in law as well. Right? Law doesn't need, a legal system doesn't need every single subject to accept it, internalize it. You can impose it. So law is often imposed. Law has been imposed in Canada since 1867 at least. So recognition, it could come from just one party, the Supreme Party. Who's actually been effective in establishing legal order? Well, they're the ones who actually have the will or the imposition to make legal order. What's interesting about these new agreements, new sources of relations between First Nations and state settler institutions in Canada is you might be skeptical about their success in changing those relations, but still be convinced that they are signaling a new way of intending and believing practices. So at that very first step, they might be suggesting that there's an alternative way of reconstructing how we think about Indigenous and state relations. And then you might also suppose, well, these are good examples because the recognition, so why I want to insist that they stand outside the hierarchy is that if you look at the letters of recognition, I should have probably put one on the slide, I mean, it's on an equal footing, Governor of BC, Chilcotin people, all right? They look very unlike the sort of pronouncements that you would have found in even the Royal Proclamation Act of 1763, where the king is declaring this and that, right? In their very structure and the way in which they're understood as government to government, nation to nation, they're insisting that recognition is shared itself as well. Recognition has been distributed across the First Nations and the government. So it's not a matter of always trying. It's a difficult thing to try and suppose that recognition actually could be shared. It need not come just from a supreme power. I mean, it could be recognition as an idea that we get from Hegel or Charles Taylor, where it really was top down. I guess bottom up too for Hegel as well. But recognition need not be hierarchical. This is the shorter way of putting it. It could really be shared. And it seems like these are pointing in that direction as examples. Thank you.
Michael, I wonder if I could ask you, do you see the social construction of state-indigenous relationships as manifested through these various devices as the decolonization process within Canada between, and hopefully a new relationship between Canadians or Canada and First Nations?
Absolutely, yeah. As a step, one step towards decolonization, reconciliation, these new forms of agreement are a step in those directions, absolutely, yeah. That's true. What I would add is that legal system is just one example of a concept which I think deserves that kind of interrogation. There are other concepts as well. So our concept of an authority, for example. So you find yourself before a judge, that judge has power over you. You've never seen that judge before in your life, but they're an authority because they've gone through a certain process of education, certification. In many Indigenous communities, to be an authority in your community isn't the fact that you've met some credentials, but rather you're an elder or knowledge keeper. You're someone who's demonstrated wisdom to the community and has respect and the acceptance of the community. That's one example where we have to rethink. The other, I think, probably one of these, possession of land. Our courts have defined possession in such a way in which it fits the English common law. Right? Think of John Locke. You own something, you own land if you've mixed your labor. And that means you've developed it, you've put concrete in it, buildings and so on. And you occupy it sufficiently, continuously over a certain amount of time. So that's the idea of a land claim from the English common law perspective. But a land claim for many Indigenous groups is quite different. Right? Often you don't want to mix your labor in the way in which you permanently alter it. Right? That's actually not respecting the land. And sometimes your occupation is not continuous, but it's cyclical. You may only come back once every 7 or 8 years, for example, or longer. So there's in the Chilcotin decision, then Chief Justice Beverly McLaughlin said, we've got to think about the dual perspectives. There's a common law perspective on land, but it also has to be viewed in relationship to or in comparison with Indigenous views of land. Now, as a philosopher of law, I sort of started making a list. So authority, legal system, sovereignty, property, wrongdoing, right? The list goes on and on, the ways in which you've got a kind of conceptual reconciliation that needs to happen. But certainly, as a legal theorist, I sort of view that as one of the prime ways in which, as a scholar, that reconciliation is a commitment, not to be taken up with. If I'm going to be a partner-to-partner and a partner-to-partner relationship, rather, or a true partnership, I've got to think about how my ways of thinking about the world are not going to be all that hospitable to Indigenous ways of looking at the world. So I think to be a better partner, I don't want this to sound corny, but my commitment to legal system has to be loosened and reworked. Otherwise, I might get caught up in the way of thinking that all we need to do is amend the Constitution and sort of re-subordinate. So that's a way of thinking that needs to go. Yeah.
I think we've come to the end of the lunchtime talk. Michael, on behalf of the McLaughlin College community, I'd like to present this to you. And we can receive one of these as if you make a presentation here at the college. So,
Okay, great. Well, thank you very much. That's very kind.
thank you very much for your presentation.
Michael,
Yes.
when you've got a spare moment, may I see you for a second?
Sure. Yes.
Now, different musics here. I like classical, western jazz, a little bit of better. Which one do you like best? Because if you come back again, I want to know.
Okay, that's very nice of you.
Because I play saxophone too as a jazz player. So,
Very interesting.
I
Link directly to
like
our-
soft jazz.
It sounded like it was something that
Yeah, no, that's very kind.
you're studying or
Yeah.
you read
well,
about.
that's very kind of you to let me play as it is. Let me try to be, I mean,